Hi everyone, Dave Sugden of Evidence at Trial. We're talking about social media evidence, and specifically what we're talking about now is the authentication of social media evidence. This is part of a 3-part video series where we talk about the method we want to apply whenever encountering social media evidence. If you haven't seen, this is volume 2. If you haven't seen volume 1, video 1, I suggest going there now. But what we're talking about now is the authentication of evidence. So what we've already determined is the type of evidence social media evidence is. In California, it's a writing as defined by section 250. In the federal rules, we're looking at evidence code 1001, looking at documents, writings, and recordings. And we've determined that this evidence is relevant. And we've done that again by looking at the rules. Section 210 in California and Federal Rule of Evidence 401. Now we're talking about authenticating or laying a foundation for the evidence. Now, this is an area where lawyers often think of authentication as some tedious, really difficult task that seems overly complicated, and it's not that hard. And yet we'll see it time and time again where a lawyer in a deposition or at trial will have not even social media evidence, but just a letter. And they'll ask the witness questions like, do you see the date on this letter? Yes, I do. Now, do you see your signature on that letter? Yes, I do. Is that the signature you usually use? Is that a true and correct copy? How about the program that you use to type up this letter? A number of questions, all of them are not necessary. And I think the reason why lawyers ask so many questions is because we're not exactly sure what is required when it comes to authenticating a document or authenticating a recording. So again, let's go to the rules. In California, we're talking about California Evidence Code, section 1400. And the language is super important. And what it says is the proponent of the evidence, the proponent of the writing, the person that wants to authenticate the writing, has to introduce evidence sufficient to support a finding. That the evidence is what the proponent claims it to be. We see the same language in the federal rules under Rule 901. And this is the key language. It's super important that we understand this, that the proponent of the evidence is required to introduce evidence sufficient to support a finding. What does that mean? Let's think of the burden of proof. If we were to draw a spectrum of the burden of proof, there are a number of burdens parties have to show depending on the case, depending on the evidence. And so, for example, in a criminal case, you have to prove someone's guilt beyond a reasonable doubt. Beyond a reasonable doubt. In civil cases, sometimes to prove malice, to get punitive damages, for example, you have to show it by clear and convincing evidence. In most civil cases, the burden is to show something beyond the preponderance of the evidence. So, what does this mean when we, as the proponent of a writing or the proponent of a document, have to introduce evidence sufficient to support a finding? It's none of these things. What we have to show the judge is that we are providing enough information, enough evidence that the trier of fact, in other words, the jury, may conclude by a preponderance of the evidence that the document is what we claim it to be. So what that means is we don't have to prove to the judge that this is authentic. And we don't have to prove it by any of these things. What we have to show is that we've provided enough evidence that the judge may or may not decide whether it's authentic, but determines that we've provided enough information that the jury can decide it's authentic. Let's consider a hypothetical. Before we even get to social media, let's assume we have a case where Mr. Plaintiff is suing Mr. Defendant, And Mr. Plaintiff says that Mr. Defendant drove his car over his front lawn and destroyed the entire lawn. That's the claim. And the defendant says, it wasn't me. In fact, the plaintiff says all of this happened on January 1st. It was New Year's Day. And the defendant says, it couldn't have been me. I was camping that day. I in essence, have an alibi. I didn't damage your lawn. And so then the plaintiff calls himself as a witness and says, I saw the defendant and he destroyed my lawn on New Year's Day. The defendant says, nope, I was camping. And in fact, while he is testifying, the defendant's lawyer shows him a photograph and says, do you recognize this photograph? And the defendant says, yes. The lawyer then says, what is it? And the defendant says, that's a picture of me camping. Let's stop there. So, is that photograph relevant? Maybe. And the idea of foundation is very close to relevance. And the question is that photo relevant? Maybe. If anything, it shows that this defendant has gone camping. And yet what it doesn't do is tie the defendant to anything on New Year's Day. And so it's probably not relevant, probably not yet admissible. But what if the defendant is asked more questions? And he's asked, do you recognize this photograph? The defendant says, yes. He's then asked, what is the photograph? And the defendant says, that's a picture of me camping on New Year's Day. Now, is that photo now relevant? It sure is, because it has a tendency in reason to prove that if his testimony is believed, if he was camping on New Year's Day, his alibi holds up. Now, the next question is, has there been a foundation for the photograph? In other words, has the defendant provided evidence sufficient to support a finding that the photo is what he claims it to be? What he claims it to be is a picture of him camping on New Year's Day. And he's provided his own testimony that says, yes, this is a photo of me camping on New Year's Day. Let's assume even, well, for a moment, that's sufficient. We have one witness saying what it is. The judge will then conclude and say, well, I may or may not believe this defendant, but there is sufficient evidence if the jury believes it. Let's suppose even before the defendant gets called as a witness, the plaintiff calls a witness, and we'll call her Ms. Witness. And Ms. Witness says, I was with the defendant on January 1st. He wasn't camping. He was actually in town. I saw him. After Ms. Witness testifies, defendant then offers the same testimony and says, nope, this is a picture of me camping on New Year's Day. So now we have Ms. Witness saying, he wasn't camping on New Year's Day, and we have defendant saying, I was camping, and that's a picture of me camping. Is there still an adequate authentication, an adequate foundation for this document, for this picture? There is. Even when there's a factual dispute, the judge doesn't resolve that factual dispute. What the judge decides is, has the proponent of the evidence, the defendant, provided sufficient evidence to support a finding. And so again, he's done so. Even though there's a factual dispute, there's an adequate foundation. To be sure, if this is an important document in the case, the defendant is going to want to provide more information to prove that this is in fact, beyond his own word, this is in fact a picture of him camping. And so he may want to introduce an example of a text message where he received it on New Year's Day from someone that took the picture. Or he may want to have evidence where he says, this is the phone that I used to take the picture. But all of those things go not to the admissibility of the photo, but rather the strength of the evidence, the weight of the evidence. And so those issues go to not the admissibility of the evidence, but the weight. This is going to make more sense as we look at some really important cases that talk about social media evidence and authentication specifically. And to do that, now go to video 3, where I talk about the cases addressing social media evidence.